colleagues, welcome to our another launching event. Today, our guest is Professor Julian D.M. Liu, QC. There is no need for introduction for him, but let me briefly introduce him. I first need to say that he is my academic father, my master, and now my mentor and good friend. Julian is a full-time arbitrator in international commercial and investment disputes. He accepts appointments as arbitrator in international commercial and investment disputes. He has been involved with international arbitration for more than 40 years as an academic counsel and arbitrator. Before 2005, Julian was a partner and for some years, the head of the International Arbitration Practice Group of Herbert Smith. Professional expertise includes international transactions affecting investments, purchase and sale of corporate entities and assets, joint ventures, oil and gas exploration, development and production agreements, research and development and promotions of pharmaceuticals and chemical products, mining and concession arrangements, distribution agency, licensing contracts, infrastructure and construction projects, international trade finance, trading arrangements with developing countries, EC law, and arbitration arising out of all such transactions. Julian has been appointed as a sole presiding and co-arbitrator in arbitrations under the rules of all major arbitral institutions and under UNCITRAL and Swiss Chambers arbitration institution rules. He is professor of international arbitration and head of the School of International Arbitration, Center for Commercial Law Studies, Queen Mary University of London. He has held these positions since the school's creation in 1985. Julian received the GAR Award for Best Prepared and Most Responsive Arbitrator in 2015. He has an enormous number of publications. It's difficult to count all of them. Julian will deliver his lecture on arbitrating in times of COVID and long-lasting implications. Julian, please.
Okay, thank you. Let me say what a pleasure it is to be here to thank you, Professor Ali, for your very kind introduction. It is true that we've known one another for a long, long time. I had the pleasure of meeting Ali when he was a student. When he came to London to do his PhD, he was a student of mine. And one of the great pleasures in life is not only having students, but when they are successful in studies they undertake, and then they become your friends and your colleagues and your mentors and people that one has the pleasure of working with. So it's great satisfaction to see him on screen and also to work with him and to commend him and also his colleagues who are here today for the initiative of establishing the Turkish Arbitration Academy, which I hope will be a great success over the years. I was the person who started the School of International Arbitration, to which Professor Ali has been associated for many years as a friend and a colleague. And he has kindly invited me previously on a couple of occasions to participate in conferences in Turkey, but it has just not been possible for me to get there at different times. So the very first advantage of COVID, before I start what I've actually prepared to say, is us all becoming used to these video sessions, that I'm able to accept this invitation, never mind quarantines, and never mind the difficulties of getting visas and traveling, etc. But we're able to see one another on screen as we are doing at this time. So over the last few years, we have all got used to a different world, dominated by COVID. And in my introductory discussion before we came online with Professor Ali and his colleagues, we asked one another about how we were doing and who had the injections and what vaccines they'd had. And this has been a major discussion amongst friends and colleagues in universities and in law firms and in businesses and in schools and with children. This has been the major focus for all of us in recent times. So it has become something which is in private and public discussions, political directions, arguments in commercial and business restrictions, adaptation and practical problems in everyday life. Above all, in many societies, we have suffered a large number of people dying, devastating for families. And many people have suffered from COVID. Some have been lucky where they've had no real effect of it, and others who've had long-term effects. And in the years to come, we will look back at this period of time with a certain amount of insecurity, because none of us could have anticipated 2 years ago that this would happen. And let's just think about this. Here we are in September 2021. In September 2020, there wasn't a vaccine. That is one of the most incredible things, and one has to commend the medical world and the political world who have done what they can. I know in many countries there's been criticism of politicians and other doctors. The reality is they've all worked very hard to try and find solutions. So we turn now to this pandemic that is really unprecedented. In many countries, they've talked about the pandemic as it was in other places, but there's no clear end in sight at the moment. The World Health Organization said the pandemic presented unprecedented challenge to public health, food systems, and the world of work. It also reported that nearly half of the world's 3 billion global workforce are at risk of losing their livelihoods. The past almost 2 years have seen extraordinarily, wherever one is based, of people who have lost their jobs, holding patterns of works, and for quite some time because of numerous lockdowns and immeasurable restrictions. It has been really quite remarkable. There have been border closures, trade restrictions, confinement measures, which have been preventing people and enterprises from accessing markets. They have been, this has included buying inputs and selling products, severe disruption to domestic and international food displays, and various other things which have made life extremely difficult for everybody going on. So many people have found their incomes lost. Big shifts have also been seen in stock markets and in financial markets. Major corporations, however big, have suffered greatly. Their values have been affected, in the most case, negatively. There's been enormous volatility in market activities for raw materials and commodities. The pandemic and the ensuing restrictions have caused one of the most significant contractions of the global economy in living memory. And very few countries, if any, can claim not to have been affected. So we're living in a time of quite significant change. Well, the BBC in England have reported that the world is now in recession. And the World Health Organization suggests that the global economy could lose over $4 trillion due to the COVID impact. I don't know what 4 trillion is. I've heard of the figure, but I'm not quite sure how one identifies that figure. So the question now is turning to our subject. What about our world of international arbitration? It has not been immune from these effects. I don't know how many of you have had the opportunity to talk to friends and colleagues. But when we has recently, how many people have recently had an in-person hearing? How much new work has been received? From what I hear, almost all hearings in the last 18 months have been virtual with people in different countries. But the beauty and the success of arbitration is due to the fact that Its inherent flexibility has allowed arbitration to adapt and to continue with new initiatives and approaches to the current abnormal times. In particular, this has led to pressure on arbitral tribunals and parties to meet virtually and adoptive proceedings for the promotion of electronic case presentation and case management tools, and the myriad of protocols and guidelines relevant to the new procedures. How many of you have been involved in a virtual hearing before early 2020? In fact, how many of you had even heard of a virtual hearing before 2020? Did you know what it involved? Did you know how it differed from an in-person hearing? Had you thought through the idea of a due process where the lawyers and the arbitrators and witnesses and the experts were all based in different places? Well, we are here now, and we're all in different places. As the pandemic evolved differently around the world, the future remains uncertain. And this also applies to many of the arbitration measures which have been developed and which may be in place for a significant period. I would not expect that all these developments will disappear, or for that matter, that we will want them to disappear. Accordingly, it is vital that both the arbitral tribunals and arbitration users will be aware of the new rules, guidelines, measures, and other facilities, and the manner in which the tribunals can operate and conduct proceedings virtually as they have done during the pandemic. So let's have a look at some of the changes that have been made. A very prominent change was the switch to technology and online filings and hearings. Prior to COVID, certain pre-hearing steps in the arbitral process were often held by telephone conference or video conference, particularly when the parties and their counsel were in different jurisdictions and in different time zones. This was particularly the case for CMCs and pre-hearing conferences. And pre-COVID, it was not unusual, but it was not the norm for certain witnesses in a hearing or experts to appear via a video link. It is noteworthy that, in fact, the IBA, seeing the practicality of this, provided that you could have such virtual appearances, witnesses, and evidentiary hearings at the discretion of the tribunal under the IBA rules of the taking of evidence. Various institutional rules also make similar provision. This was an option available to parties and tribunals, which was only exercised in rare circumstances. It was not mandatory and not widely used. What's new now in the post-COVID world? Well, as we've all experienced, parties, counsel, and arbitrators have been obliged to participate in hearings using Zoom, WebEx, and the other video platforms to conduct meetings, conferences, and hearings in a virtual format. By necessity, the barriers to entry for these technologies in international arbitration appear largely to have been overcome. Before COVID, counsel and arbitrators often resisted video conference technology due to concerns about whether it would function properly. And there were also data and cyber security concerns, which in some ways remain. I recall vividly cases in which I was involved, where one would agree on a video, and for some reason, the internet strength would disappear, it would break down, and we would lose control, and it would undermine or at least hamper the hearing in many ways. From a counsel's point of view, it takes away the momentum of presentation. From a tribunal's point of view, you lose the benefit of the evidence and argument that would have been presented. Another concern was and remains that the relationship between parties, their lawyers, and the tribunal would be more difficult or even impossible to establish through technology than in person. There can be little doubt that the atmosphere of all participants in arbitration sharing the event does assist in developing a common respect and understanding of the approach and the attitude of the parties, and from a tribunal's point, their lawyers. To the extent to which that may affect or may influence a decision is far from clear. Many think it makes little distinction when it comes to the final decision of right or wrong, breach or no breach, and meaning of contractual provisions. At the end of the day, it would always depend on the particular circumstances of the case, as well as what counsel, parties in the tribunal involved feel comfortable with to resolve the case in an efficient and effective manner. From being an option, rarely used but occasionally used, available to parties, for specific use, using technology has now become the status quo, the new normal, which was quickly recognized by arbitral institutions. And as a result, many of them have amended their rules to reflect the current needs of the arbitration users in light of COVID-19. Institutions have moved extremely quickly, and in some cases have done so with the effect of taking consultation and to develop issues. Lawyers and arbitrators, however busy and well-known, could only experience a limited number of issues prior to COVID. And the institutions, having the benefit of different cases with different tribunals, have obviously had more experience than individual arbitrators. And the institutions rose to the challenge. In April 9, 2020, that's just 2 months after the pandemic started, and maybe before some countries had even realized the effect of the pandemic, a group of arbitral institutions issued a joint statement seeking to promote stability and foreseeability in the unstable business environment caused by the pandemic, and simultaneously wanting to assure arbitration users that, and I quote, pending cases may continue and parties may either have their cases heard without undue delay. As a result, many of these institutions adapted their operations in view of local quarantines, lockdowns, contact restrictions, office closures, and with that has also amended their rules accordingly. And we all know how hard the institutions have worked by having members of their counsel, their legal teams, working from their private homes. But what are the changes that have been made? Well, first of all, filings and submissions. There's always been the tendency of many lawyers to like lengthy documents written on paper, carefully checked. And arbitrators have enjoyed that as well, something they can mark up with a yellow sticky and with a yellow pen. Well, the clear trend that has emerged favors now not only electronic submissions for the parties, opening submissions, but also for all submissions generally. And this has become quite the norm. The parties are exchanging electronic documents, are setting up platforms specifically for arbitrations. And the systems that existed have now been further perfected. They may not be perfect yet, but the developments in 18 months has been remarkable. So what has happened is that the ICC and the ICDR expressly now mandate electronic-only submissions of requests for arbitration and other documents. The LCIA requests all new arbitrations be filed through an online system. And I'm not going to go through all these rules to show how what the institutions have done. These rules will depend on where one has an arbitration and how one should look at it. But they do bring home a basic rule of arbitration, that one should be conversant with the rules of the relevant institution, or if it is not an institutional arbitration, the rules that govern that arbitration, either ad hoc rules or national rules, depending upon where the arbitration is taking place. And so all of these institutions, including ICSID and the Stockholm Chamber of Commerce, have electronic arrangements now for most of their, for all of the submissions. And it's up to arbitrators really to indicate when and if they want hard copies of these documents. Well, there are institutions have also issued guidelines, very helpful guidelines, and not always clear, but which they have hoped would help. The ICC has a guideline to mitigate the current difficulties with submission of hard copies, and tribunal should encourage the parties to use electronic means. The SIAC, Stockholm, as Singapore International Arbitration Court has similarly provided that if COVID-19 has resulted in circumstances to prevent you from meeting any timelines, please make an application for an extension of time. So that's the one thing. Everybody's aware of the difficulty of that COVID has created. These issues, these directions were given some time ago, and many of us have got used to the effect of COVID, but the institutions and the rules are there with great flexibility. What about hearings? Hearings present a very interesting position because we all know the importance of due process. Opportunity to address the tribunal, to answer the arguments put by the other side, to present witnesses, to examine witnesses, to hear other argument. Well, in the past 18 months, the norm has been for virtual hearings. Travel internationally has not been possible. Even if where parties have sought in-person hearings, many parties themselves, witnesses, experts, and lawyers have had been reluctant to travel distances across the world. And even if there were, many are unwilling to sit in a room with 15, 20, 25 people, 3 arbitrators, party representatives, lawyers, paralegals, witnesses, experts, arbitrators, and anybody else that's needed, translators. And what kind of ventilation will there be? And even if all those present are masked, masks are not really conducive for a 6, 7, 8 day hearing. By contrast, parties, lawyers, witnesses, experts in different corners of the world and in different time zones will have difficulty having a hearing which is virtual. If you think of a case where one party is from Japan and the other from the west coast of the United States, with parties in Europe as well, there is a 16-hour difference in time zones. And that would create difficulty in how to find a way to bridge that time zone so that parties can be considered to have a working system which is hospitable for all of them, maybe only able to work for between 3 and 4 hours of work a day effectively. So parties may be willing to compromise and to move people to the same time zone, even if the arbitrators are in one place and the lawyers are elsewhere, and witnesses, experts in a 3rd or 4th place. So what has also happened is parties have now started looking at the possibility of hybrid hearings, where large parts of the hearing would be virtual with everybody in different places, and also where a hybrid hearing, so for a small part of the hearing, parties would travel the time, be in the same time zone. Some would be together in person and others not. This is something which is being involved, coming out increasingly at the moment, and we'll see how things develop. There also seems to be a trend that parties are saying, well, if we can't be there together with the tribunal, at least the tribunal should be in person together, and the lawyers and the parties and the witnesses to be separately in another place. And all of the arbitration institutions now allow remote hearings and provide specific guidelines on how to organize these hearings. And it's very useful for counsel and for arbitrators to have a look at these guidelines issued by the ICC and by ICSID and by others, which show the factors to be concerned about. Many of them we can identify ourselves, but of course in every case is different. It depends upon the technological ability of the parties, of their counsel, the advancement of individuals involved, the nature of the teams. There needs to be strict rules about who should be talking and who should be muted, whose picture should be available. And all of these issues are such that these issues need to be determined. So it's important for counsel and parties to become aware of these different issues. As a result, online platforms and protocols have been developed. The institutions have made significant efforts to assist the parties and tribunals in the way they conduct arbitrations and the guidance and organization with regard to the promotion of hearings. And so this is why I mentioned the ICC published a guidance note, mainly focused on the issues of virtual hearings. Very extremely useful. And it suggests that third-party comparative table, available video conference platforms, and recommends the use of certain licensed platforms to ensure maximum security and confidentiality. Security and confidentiality in all arbitrations have always been considered a very important element. And it's interesting that sometimes we forget these factors, but the parties don't. And one also needs to look at these platforms to ensure that the security of the parties' confidential information and of the very details of the arbitration are kept confidential. And other institutions, various other institutions also have developed practices for virtual hearings, such as online document repositories, allowing for the electronic transmission of evidence, which has now become increasingly common and extremely helpful. And it has also issued guidelines for virtual hearings. The Vienna International Arbitration Center has also developed a protocol and a practical checklist for remote hearings. And all of these issues need to be looked at carefully before going into an arbitration. I'm not going to go through the rules of all these different institutions at this stage, but I do commend them to you, particularly if you are involved in arbitration under these different institution rules. And it may equally be so that if you're agreeing on an arbitration under the rules, the parties and counsel should look carefully to see which rules are suitable for their requirements. There's also the question of an arbitration award, and as you will all remember, the needs of an arbitration award to be final and binding, and it requires the signature of arbitrators. Well, it's pretty difficult and has been difficult in COVID times to get 3 arbitrators together at the same place to be able to sign an award. And if this award has to be circulated worldwide, the time that is lost, etc. So what many institutions have done is to provide that an award will be notified in electronic form if the parties agree. And they will be notified of the award also by PDF, by a scanned copy, and the award will then be sent by courier as soon as is possible after that. Arbitrators' signatures are accepted now in electronic form, provided the institution is contented and the parties are satisfied. And I guess we'll have to wait and see that the courts will accept. National courts, when asked to recognize and enforce an award, will accept that these signatures, electronic signatures and scanned awards should be given the same effect as an original. And so the institutions here do come up with practical solutions in the way that they would like them to be dealt with. And finally, let me say this, that before I go on and talk about the future, that some institutions and organizations that provide arbitration facilities have looked at the existing situation and have spent some time trying to develop facilities that will help the parties. So there are arbitration hearing rooms, facilities, which are now specifically equipped to assist and manage both virtual and hybrid hearings. They've always provided these facilities, but of course they are increasingly sophisticated as a result of the work in the past few years. So we are where we are, and there's not much we can do about it. I asked some colleagues recently, in fact, quite a few colleagues recently, how many have had in-person hearings. And everybody said, oh, I haven't had any. And then one said to me, well, actually, I had one for 2 days last week. And I'm aware of another one which has been going on of some colleagues of mine in Geneva for the last 2 weeks. And I know of somebody else who's got an in-person hearing in London in a week. So they are coming back slowly. A lot depends upon many factors, and many people are still reluctant to do so. And as I indicated earlier, one has to make sure that before one could adopt a situation of this sort, one would have to be certain that the protection of all those involved, and that goes from the transcript writers and the translators, are all going to be safe, as well as the lawyers, the junior lawyers, the paralegals, the witnesses, the experts, and also the tribunal members. So it's hard to predict which of these measures that have been adopted in recent times will continue to be relevant when the pandemic is over. My own view is that we are going to see many of them enhanced, and we're going to see more and more of them continue to be used. And there are many reasons for that. So the question is, will parties go back to in-person hearings and procedural meetings? This is important when it comes to the number of employees one would have working in institutions and also in law firms, and the safety precautions that will be necessary. So it's not clear at this stage what will be required. Interestingly, the Queen Mary and White and Case survey of 2021 reported that technology is widely used in international arbitration. This is a review done after the COVID-19 became normal. Video conference and hearing room technologies are being widely used. 79% of respondents who answered the survey said that if a hearing could no longer be held in person, they would choose to proceed at the scheduled time as a virtual hearing. Only 16% said they would postpone the hearing, which should be held in person. And from my own personal experience in my own caseload, whereas a year ago, even 6 months ago, parties were saying, well, let's adjourn and let's have a hearing at a later stage, let's fix another date. Parties are now beginning to wonder whether they shouldn't just go ahead with a virtual hearing at a sooner date. because I had one case where we postponed a case for 9 months, expecting that in 9 months COVID would be over and under control, and it's not. So these are very live issues which parties have to look at. And I think parties have learnt that it's possible to have the tribunal reach a conclusion, having taken into account all the parties' arguments and the evidence on the basis of a virtual hearing and written pleadings as well. So the preference for virtual hearing is also partially based on an expectation of reduced cost. This is not surprising. There's often been complaints about the cost of hearings. But if you have an international case with parties from 2 different countries, whether they be at different corners of the world or even different sides of Europe, flying a legal team from one country to a third country, or from both countries to a third country, and arbitrators from different places is an expensive event. The cost of travel, hotels, subsistence, etc. One is bringing also witnesses and experts to the hearing. One has to determine whether it is worth it. And that is a matter for counsel to decide. And I would expect that whereas parties and lawyers determine that not all issues need to be dealt with in person, it may be that some parts of the hearing will be kept for separate issues. And let me give you an example of certain situations. For example, there may be an argument as to what is the applicable law in this particular arbitration. And whatever that applicable law is can be argued out. The facts will be in the record. Unless the facts need to be determined, the arbitrators will be able to listen to the arguments, read the arguments, and reach a conclusion. There may also be issues of, even if they need to hear from experts in something like the calculation of damages. That is also an issue which may be calculated on the basis of hearing the experts on a video argument, having examples put up in on screens so one can look at the calculations. Other technical issues will be the same, and the experts can then present their case and argue it accordingly. I'm not suggesting this will be the case for every situation, but it may well be a case for some situations. And I think there is the third type of hybrid situation, whereas we're beginning to see, and I've mentioned already, we'll see parties coming together to have the lawyers in one place and the arbitrators somewhere else, until everybody is comfortable being together in the same place. I'm not sure we're there yet, because from my experience, too many people are still uncomfortable traveling very far and talking in large groups. But we'll see. At the end of the day, the manner in which a hearing takes place will depend on the circumstances of every case, and this will depend on the extent to which the tribunal and counsel are comfortable using technology or not doing so. So I think I'm going to call that there and say that I'll just finish with a little anecdote of something I said some years ago. I was asked at a talk on where did I see arbitration going. This is probably about 15 years ago, so before anybody dreamed of COVID. And I was asked, what did I think the future would be? To be honest, I didn't think that much about virtual hearings, but I went to the next stage, and maybe this will be our next stage. And I suggested that what would happen is in years to come, every time a baby is born, the doctors will put a little electronic or computer chip in the back of a baby's ear or in the palm of the baby's hand. And that the baby will grow with, and every human being will have this. And so when parties have an arbitration, everything will be communicated telepathically through this chip behind the ear or in the palm of the hand. So a party that's in a contractual relationship won't have a contract, they'll have it all in the computer like we have it electronically now. they'll have it inside the chip, and they will send that to the lawyer who will receive it in the chip, and they will analyze it in their brains and give advice on the chip, and they will start the arbitration by filing through the chip. They'll file a hearing note with the institution. The response will come into the institution. There'll be no paper. There might not be anything electronic. It'll all come through this chip telepathically. And then the arbitrators will be appointed. They will receive the request for appointment again through a chip, not through letters, not through an email, maybe not through some other virtual system, but there'll be a mechanism getting the message into the arbitrator's head. Do you have a conflict? Can you accept appointment? Do you want to accept this case? Arbitrators will be appointed. They'll give directions to the parties. They'll receive the arguments. They'll see the pleadings. No paper. Nothing on screens. All on the chip into their brains. And the arbitrators won't meet. They might not even talk, but they'll communicate their thoughts through their chip. And they'll reach a conclusion, and they will agree on the award of who wins and who loses and who's pays and how the cost should be divided. And they'll agree all of this through the chip. And then they will issue an award. And it'll be just as we would see an award now on paper. It would arrive on the parties and the lawyers into their chips. There it would be. There'd be a final award, agreed. And I got two questions that remain. First, will the national courts recognize that? And how are the arbitrators going to get paid? Thank you very much.
Thank you very much, Julian. Probably through the chip, the payment will be made to the bank account of the arbitrator. Thank you very much for in-depth analysis of implications of COVID. As it is always the case in your lectures, there's no question because the subject is greatly analyzed by you. Thank you very much. And we are now stopping broadcasting.